Thank you. So it is 5:04 on February 24th, 2022, and we are here with the Joint Committee on Judicial Retention. And we are starting at 5 p.m. this evening because we are taking up a visit from Judge Carrie Ann McDonald Cady, who we had extended her visit to tonight. So Judge McDonald Cady, you're still on?
I think we just lost her.
Yeah, I'm not seeing you.
Well, sometimes the TV pixelates.
Oh, there she is there.
You went live and I disappeared.
Yeah, you did.
Okay, I'm back.
It's fine. So we're going to introduce ourselves, and so you know who everyone is. And in the upper corner tonight is Senator Nitka. And if you would, Alice.
Hi, I'm Senator Alice Nitka. I live in Ludlow, and I'm a senator for Windsor County and a few other towns. And I'm on the Judiciary Committee and the Appropriations Committee.
Thank you. Dick?
I'm Dick McCormick, and I represent the same district, Windsor County, Londonderry, and Mount Holly with Senator Nitka.
Hello, Senator McCormick.
Thank you. Ruth?
Thank you, Mr. Chair. Good evening, Judge. I'm Ruth Hardy. I'm a senator from the Addison District, which is all of Addison County, plus Huntington and Buell's Gore. And it's nice to be with you tonight. Thanks.
Thank you, Senator Hardy.
And Representative Knott.
I'm Representative Wilmot. I represent Rutland 5-4, which is the northwest section of Rutland City. Currently serving my second term as a representative, and I am on the House Judiciary Committee.
Good afternoon.
Sweeney.
I am Representative Selena Colburn, and I represent Burlington's Chittenden 6-4 district, which is kind of UVM and the hospital and many of those surrounding neighborhoods. And I am in my third term in the House and my third term as a member of the House Judiciary Committee.
Nice to meet you, Representative.
Nice to meet you.
Colburn. Nice to meet you.
Hi, I'm Representative Butch Shaw. I live in Pittsford and I represent Brandon, Pittsford, and Sudbury. I think I'm in my 6th or 7th term in the House, and I serve on the Transportation Committee in the House as Vice Chair. Welcome.
Thank you.
Hello, Representative Shaw.
Thank you. And I'm Chip Troiano. I represent Hardwick, Stannard, and Walden up in the Northeast Kingdom. I'm the Vice Chair of the General Housing and Military Affairs Committee in the House. And I'm the chair of this committee for this year. And so welcome, Judge.
Thank you.
We're happy to see you here tonight. And we would anticipate some opening words from you. And so the mic is yours.
Okay, thank you. So I prepared a written statement mostly because I'm a little bit nervous and I just want to make sure that I was touching upon points. So I'm multi-screens in my office, so bear with me as I read from the statement. So thank you, first of all, for inviting me and again for letting me come today rather than 2 weeks ago. And also for last week, I know that I was listening and watching and had speakers that weren't working. And when you called upon me, children were also in Zoom meetings. So when I was saying, please help, I was listening to live on my phone streaming, which I thought was clever because I could hear it and watch you on my computer. But when you did the call out, I did not know how to reach you. So thank you and for bearing with me and the good humor of not holding that against me, my technical difficulties. So.
No worries, Judge.
So prior to tonight, I've had the benefit of listening to my fellow colleagues in the judiciary who've also come before you seeking retention. They are judges who I admire, respect, and aspire to be like. I have tremendous respect and appreciation for the work that they do and their ability to make it look effortless, because when in fact, this job is extremely demanding. I began my first day on the bench on December 16, 2019. I was excited and nervous and ready to take on this new challenge in my career. Learning how to judge involves a steep learning curve, And I've tried to take that on with determination, humility, and patience. And patience is essential in the transition from an advocate in the courtroom to a judge. And it is not a transition that is innate. It requires practice and a willingness to learn to improve. Additionally, the impact of learning how to be a judge during a global pandemic has raised new and unexpected challenges related to conducting judicial hearings remotely. And those challenges included hearings that take longer to complete now, unequal access to remote technology among litigants, and upholding the dignity of judicial proceedings when they are taking place in the privacy and the comfort of one's own home. An unfortunate consequence also was the restriction of hearing only emergency hearings for about 2.5 months only. And then once that restriction was limited or removed, there was a limitation of conducting hearings only 5 hours a day. And that created a further demand for court time. My first year as a judge also included learning how to use the new software Odyssey. And that allowed me to work on cases electronically without using paper files to read and prepare the cases on the docket. So that was another transition of learning the first year of work on the job. I approached my first year on the bench as an opportunity to listen to the bar and the litigants and to learn a new area of law that I had not practiced before, divorce law, and to gain insight about what worked in Bennington and what, if anything, did not. I scheduled quarterly bench bar meetings in the domestic and juvenile dockets, and that was a further opportunity to reach out to the stakeholders, keep them updated about changes in the judiciary related to COVID-19, and to let them ask questions and raise concerns. And I also met with the staff and requested yearly review meetings with our court operations manager, the COM, and the regional clerk to identify ways that I could improve to be a judge, and especially in docket case management. And I recognized even before reading the survey results that an immediate need for improvement was in finding time in the domestic docket to hold emergency hearings. There was no ability to place emergency hearings on the docket quickly because of the volume of the cases that we have, and that they're often scheduled 2 to 3 months in advance. As a result, in December, when I spoke with the COM and the regional manager, or the regional clerk, I asked them to create a domestic emergency block. And that we started this month, which is every Wednesday for 1 hour. In my December meeting with the regional COM and our COM, I also asked if we can create a self-represented litigant block. And we are doing that now every Wednesday morning. Most cases in the domestic docket here in Bennington County involve parties who choose to represent themselves rather than retain legal counsel. And it is more typical today to have 2 self-represented litigants in a contested parentage case or post-judgment litigation rather than having 2 attorneys represent the parties. The self-represented litigant block addresses multiple cases in a traditional single case block. And this allows the court to identify or better identify contested versus uncontested issues early on and to schedule those cases for future hearings more accurately and with the goal of using court time more efficiently, which then would alleviate some pressure on the overall domestic docket. And again, we began using this block this month, and so far it is working very well. I also recognize the critical importance of strong management of the docket, and I recognize this is an area that I need to improve based on the comments made by both attorneys and non-attorneys. I am grateful for all their comments, both positive and negative, because it provides me with a roadmap of what I need to do to improve. I'm hopeful that with my ideas that have just begun to take practice, along with further training and continued mentorship, that I can improve in this area, and that's to meet the expectations that have been set by the other members of the judiciary that I admire. I also recognize the great responsibility that's been entrusted to me as a judge. In both the juvenile and domestic dockets, I'm making decisions that impact parents and children, including the most solemn decision that I think that one judge can make, and that's the decision of whether to terminate the residual parental rights of the mother or father. As a former prosecutor, I'm also keenly aware of the perception that I may be biased towards the state or children based on my past career. I've worked hard every day to treat litigants and the attorneys that appear before me with respect and to treat them fairly. And I demonstrate this each day by allowing the parties to speak, to ask questions of me in the courtroom, and to present his or her case in the same amount of time that I designate for all the parties, and to apply the law and the Vermont rules of evidence equally, regardless if it's the state or a parent's attorney or someone that's represented by counsel or a self-represented litigant or an attorney representing a child. I'm personally moved by all the difficulties that parents have faced, and they are often attributed to substance abuse disorder. However, I'm bound by the law, which I try to do to the best of my ability every day, and I often directly acknowledging the parents and the parties and the adversities that they've faced in my decisions. Despite these efforts, I do know that I still have work to do. I was deeply concerned by the comments raised in the survey that there are those who believe that I'm biased. And although most participants did not raise this as a concern, and they rated me good, very good, or excellent as being free from bias, the negative comments deserve attention, and I respect all the opinions. I recognize that the negative comments can be extremely valuable, and they can help me improve, and give me an opportunity to improve as a judge. And that is the goal that I have every day that I set for myself, to be better than the day before. As I stated in my supported statement for retention that I filed back in August that I was rereading in preparing for today, public service is the reason that motivated me to step forward to seek appointment to the judiciary. And I am very happy to respond to the committee that public service continues to be the very reason that I find this job as a judge to be so satisfying, even on very stressful and difficult days. I am committed to learn new ways to judge fairly, impartially, and effectively, and I'll try to continue to do that. So I thank you for the opportunity.
Thank you, Judge McDonald, Katie. So I think there probably are some questions from members of the committee, and we'll rotate around and alternate House and Senate. And let's start this evening with Representative Knott.
Thank you. So on your, in the feedback from your questionnaire, I really felt like there was almost, and I wrote down in my notes that it's almost like there's two warring factions. It's like there's the group that is really impressed with the time you take and the work you're doing, and making certain the children's voices are heard in the court. But there's also concerns about time and the delays and the way that impacts the courts. So I was just curious for your thoughts on how do you strike a balance where you are feeling like every voice is heard, but perhaps things that can happen while things are still moving at a faster, more expedient pace.
So it is a difficult job, and it is harder now even with remote hearings because they take longer. So I think my job is two factors. One, you have a docket, and it's important to get through the docket to make sure that you get through all the cases, because delay is very difficult to try to reschedule that. And I spoke with the COM and the regional COM about the importance of making sure that all the cases are heard and to try to do that timely. And one of the changes that I made for 2021 is adding a little bit of extra time to certain cases and identifying them so that I was able to add in time for myself. In other words, time for all the parties to be able to speak, but time for myself to speak at the end, because sometimes there wasn't time for me to do that. So now I look at cases and I add a little bit more time, which has really helped, especially if there are cases where I'm able to issue decisions from the bench. So that's one change that I made. And then reviewing that with the COM and the staff, that really satisfied some concerns early on. I give everyone an opportunity to be heard because people wait a very long time for their day in court, sometimes months, and I don't want them to feel rushed. I feel that when I have their case in front of me, that is the only case that's the most important case, and I'm trying not to think about the emergency cases that I know that are an odyssey waiting for me or the docket. So I really am very hyper-focused on the parties that are speaking to me, especially the parents when they want to say something or ask a question. I always give an opportunity for them to do that. And that becomes difficult when they want to express more issues than maybe what the court hearing was set for. And I think it's just my personality that I don't cut someone off, especially when they are impassioned or when they're revealing something very personal and moving. I think what I try to do is find the right moment where I'm able to transition and just express to the parents that I appreciate what they're telling me, because it's usually parents in the juvenile docket that this often happens with. And then I express to them that we've used all of our time for the hearing, but what they've raised is valid, and that I'm going to address it either in the next hearing or to set another hearing more quickly so that we can continue the conversations or questions that they have. And I do my best to try to explain to individuals that if I haven't been able to address everything that they wanted to speak about, that there are other families and litigants that are waiting for their day in court, and their hearing is equally important, that I don't want to be late for. It is a tremendous, difficult balance. It's more of an art than a format, but I just try each day to look what worked well in one hearing and then try different techniques. But across the board, I let everyone speak. I just try to focus on what the purpose of the hearing was. And then if we're going over in time, to determine, do I need to set it for another hearing to continue the discussion about any issues that were raised? But I understand it is a difficult balance to make sure that you get the work done, hear from everyone, keep on track. And it is something that I work on each day because there's always improvement. There's always something to learn. So.
All right, thank you. That was the only real big question I had. So thank you very much, all set.
Okay,
Thank you.
Thank you, Senator Khan. We'll hear from Senator Hardy right now. You have some questions for the judge, Senator?
Yep. Thank you, Mr. Chair. And thank you, Judge McDonald, Katie. One of the things I am curious about is, well, you're a new judge and you started under really stressful situation with the pandemic and a new system, et cetera. And congratulations on making it through your first, is it 2 years as a judge? It's been kind of a hell of a time for everyone. So starting a new job like yours is especially hard. One of the things that seems like you might be struggling with, and I'm wondering your thoughts on this, is the role of a judge versus the role of a social worker. And this was brought up in some of the comments. You're clearly incredibly empathetic and experienced, and you want to make it right for everybody. But you have a particular role as a judge to play, and that obviously is your first role. So how do you think you can balance that, or how could you balance that better and be less of a social worker and more of a judge, or maybe both? Or what are your thoughts on that issue?
Thank you. So I thought that was a very good comment because it gave me some insight about, perceptions again of what's happening in the court. And that's probably directed in the juvenile docket because that's where DCF, that's where social workers are. So at least from my perspective, I didn't feel that I was social working, but I ask a lot of questions. And so that's given me some perspective of maybe the questions that I'm asking seem to be social working. We have an excellent DCF office here, and I rely heavily on them for making those difficult decisions about social working. I don't second guess them, but I ask a lot of questions. And I do find that that is my role as a job, to ask questions. In other words, not to just accept reports, not to just accept recommendations, but to ask, why are you asking for a child to be removed from the parent's home? Why is it not an ability right now to transition from custody to a conditional custody order? What are the issues that are the immediate danger preventing from a child from being returned to the home? Why can't visits with a child and a parent be 5 days a week? So I ask a lot of questions. And the questions that I ask are to make sure the decision to remove a child, is that still a valid decision? Are there still a concern about safety that has not been mitigated to allow the child to be returned to the parent under another order, conditional custody order? So it's helped me because I don't want the bar or social workers to think that I'm social working, because I'm not, and that's not the role that I want to play. But I do want to make sure that my answer or my questions about are reasonable efforts being made to try to return a child safely to a home? Is that being satisfied? Because that is a responsibility that the court has. And I feel the only way to determine if reasonable efforts are being made are asking those deeper questions about the work that's being done. So I think it's given me perspective to understand that may be taken of me trying to take on the role of social worker, which I clearly am not. And I appreciate the social workers, because in the end of the day, I am relying heavily on them to make those determinations in the field of what's safe and what's not. I don't go out to the home. I don't visit the home. I don't investigate that. So there is a lot of trust that I'm placing with social workers. But in order to gain my trust, I want to make sure that they're doing the work. So I do ask a lot of questions. And I thank them for the questions when I ask them, but it helps me to feel confident in the orders that I'm making, because that's really a hard decision, especially young children or even infants. Am I making the right decision? Is there really a safety issue here preventing the child from being home with a parent? So that's, at least from my perspective, of why I ask those questions. But it's really helpful to understand that's being perceived, at least by some, of social working, which I don't want to do, because we have excellent social workers here.
I very much appreciate your answer to my question. As this committee knows, and all of my committees know, I ask a lot of questions. And so I very much appreciate the power of asking questions and the power of getting the information you need before you make a really important decision. So I appreciate that. And I do have another question for you, if I may, which is one comment that I noted in one of your letter, I think, that you presented with your materials. You mentioned about how you weren't sure about how you felt about a case until you started writing about it, and then you realized what the decision was. And as a writer, I very much appreciated that as well. So I'm wondering if you could talk a little bit more about your writing process.
So there are some cases where the evidence is very clear, based on what I know what the law is going into a case. I may not have some ideas of what the facts are based on the filings, but at the end of a case, sometimes it's very clear what my decision is. But other times, like for example, the writing sample of the Maori case, it wasn't quite clear. So, and that's hard to take out because it shouldn't be your emotion that's drawing you or driving you of your decision. It should be the facts and what the law is, and apply it equally and fairly. So what I found really helpful is to start writing what the facts are that I found. And that's what I do. And I try to do that close after to a hearing, or at least on my drive home, to write down a couple of issues or a couple of ideas that are just that I'm thinking about, because that's what I tend to do on my way home, process what happened at a hearing. And then I sit down and I just write what the facts are, because I have to start with the facts. And then once I have the facts, then I apply it to the law. And then it becomes really clear, this is the decision. And that helps me with the difficult cases, because I feel like it takes out the emotion or maybe bias or hunches, and it just really applies. This is what I found. These are the facts, and this is what the law is. And it feels, for me at least, a very satisfying process, because it takes out the concern of, did I maybe make the decision and side with someone based on something that I shouldn't have considered? And so that's how I apply at least my writing style for especially cases where I'm not quite certain because of the compelling argument and the facts by both parties. Some cases are much more clear, and I still start with what the facts are. But in the cases where I'm not quite certain, I just let the process take place of, what are the facts? What did I find compelling here? And then I apply the law. And that really tells me what my decision is. So.
Thank you. That's great to hear. I appreciate it. Thank you for your answers. And thanks, Mr. Chair.
Okay, thank you, Senator Hardy. So I didn't mention that we are working tonight without the presence of Senator Benning, who is a member of this committee and is unknown as to his whereabouts at this point. He has not joined us Maybe he is under the impression that we begin at 5:30. So we will watch for Senator Benning. He's very reliable, and I'm hoping to see him tonight. And I also wanted to thank Peggy Delaney tonight. I often forget to put a thanks in, but she really keeps us all working on this, and she does a really fantastic job. So on that, Representative Shaw, do you have some questions?
Thank you, Mr. Chair. I have just one question, and especially I'd like to ask this question to new judges, and because you are cast into a very difficult, time-consuming job that could potentially overwhelm you and keep you in a courtroom all the time. And then I noticed in your supporting statement, you talk about taking work home and writing decisions and other issues at home. So my concern is not necessarily your judicial temperament, but what do you do to keep yourself on an even keel, balance your family with your job, and just refresh yourself for the courtroom? I'm thinking that's got to be a very difficult process for you to do.
It's a good question. So I have 2 kids and a husband. My son Jack is 15 and my daughter Mary is 13. And we have a 1-year-old dog. So there is always commotion and excitement going on in the house. They are big into sports, so they play basketball, and we enjoyed field hockey and football season. So when I am not working, I'm spending time with my family. I mean, those are the 2 places that you would find me. And they are the place where I find the balance. They are the place where I find the peace, because it really is sometimes overwhelming and difficult, because you are seeing people not at their best in difficult cases. So even as a prosecutor, I found that the place of finding the balance was your family. So we do a lot of things. We're pretty active. During the winter, we ski. So I try to get out on the slope so I don't lose my nerve and make sure that I can continue to ski. We do a lot of snowshoeing, which we're able to just go out in our backyard, and we have lots of woods out there, which we really enjoy to do. We go ice skating. During the summer, we do a lot of fishing and swimming and water skiing. And in both seasons, we do a lot of hiking. And in particular, we go to national parks. That's something that we started when the kids were young, and actually before, when my husband and I were dating. So we tend to do camping as well. So, and with a dog, that's a whole new experience as well, training a dog. But she provides immediate entertainment and ease, because she doesn't understand why are you working, and we'll come in and I'll know, okay, it's time to go for a walk. And so I think that balance is really spending time with family. And I have to tell you, with my mom, it also just rings true of, you got to get out there and exercise and make sure you're putting yourself first. So it makes it really clear of, okay, time to take a break. And then I also feel that, in order to be a good judge, I need to be rested. I need to have my mind at peace, and I need to be refreshed every day. So that's really important, where I know that, okay, it's time to go to bed. It's time to put the work down, so that in the morning, the person that's on my docket gets me at my best. And I'm really cognizant of that, so that in the evening, even if it's late and I have some more work to do, I put it down, because it's going to affect the next person the next morning. And I don't want that to be the case. I don't want them to have a tired judge, or a judge that, had a bad day or didn't get to go out and exercise. They deserve to have a judge at their best. So I'm really pretty aware of that. Quitting time to go out, time to spend time with the family.
Thank you. And I heard you say taking a break, that at this stage of your career as a judge, taking a break may be the most important thing you do for yourself. Thank you.
Thank you.
Thank you. Senator McCormick, do you have some questions for the judge?
Thank you, Mr. Chairman. I'm sort of digging for questions, because the fact is your reviews are very good, and the only negative stuff I see, they're all outliers. They're, in some cases it's one person, but I guess I'm going to focus the negative, because otherwise I'd just say congratulations, good for you, and leave it at that. What about the idea that you have someone out there thinks you tend to favor the prosecution? That you have and then you mentioned you were a prosecutor, so is it just old colleagues or an affinity, and what do you do about that?
Like I said in my opening statement, I was aware of not a career prosecutor, because I also practiced private practice for 7 years, but that might be the perception of even before starting my first day. So I think what I do is I treat everyone the same, meaning everyone has the same opportunity to present their case. The state doesn't have any more time than a juvenile's attorney or a parent's attorney. That I apply the law, apply the rules of evidence equally, and that I hold each party to the burden of, if you're the moving party filing the petition, it is your burden. I think what I need to do is, continue to work better to explain my decisions. And I think that, at least right now, I try to do that, whether that's orally on the bench or in writing, to explain these are the facts that I found, and this is the law, and this is how I applied it, and this is why I decided the way I did. But I do understand that there are at least one, maybe two individuals that feel that's the contrary. So I think it's to continue to do what I'm doing, to treat everyone equally, to continue that method of each person gets the same amount of time, and to just continue to try to explain my decisions better. Whether that's pointing out more clearly what the facts are that I'm relying upon, or the law. But one thing that I do is I never issue a decision that says the motion is granted, or yes, I agree with you. I always explain why. And the reason why is for this very reason, so that someone couldn't understand, well, why did the judge side with the parent's attorney, or why did the judge side with the state? I always explain what were the facts that I considered compelling and how I applied the law. But I'll just continue to do that. And I think just try to do that more clearly and better. And just, I don't keep count. In other words, I don't say, well, I issued 10 decisions for the state. I probably need to issue one to the juvenile. I mean, that is not what you're supposed to do. And I don't do that. I base it on what the law is and what the facts are presented. And so that may look like the state is successful one day. That may look like the juvenile is successful one day. That may look like a parent is successful one day. But I don't keep track of that, because that is not my responsibility. That's not what my duty is. That's not what I took an oath. I took an oath to really follow the Constitution and apply the law fairly. So I just try to do that every day. And I think that's what I'll just continue to do. But just be aware that some people feel that I'm not doing that. So I think it's trying to find other ways to just be more clear about why I decided. So.
Good answer. Thank you. Thank you, Mr. Chairman.
Thank you, Senator McCormick. Representative Colbert, you have some questions?
At this point, I think all of my questions have been asked by other people. So I'm not going to ask you a question, but to say I really enjoyed reading your materials, and like Representative Knott just found, really interesting kind of the the amount of comments that really talked about the time that you do take, and really about being a model of kind of trauma-informed practice and your work with pro se litigants, and then some of the challenges that folks cited about time management. And so I appreciated really hearing your answer about how you balance those things, and look forward to continued conversation.
Thank you.
Thanks. That's it.
That's it. Yeah, we'll have a question.
So I see Senator Benning has joined us. A little mix up on the starting time there, Senator Benning.
Well, Mr. Chair, unfortunately, I had put into my calendar the link from last week, which is why I'm a half an hour late, and I couldn't get in.
That's what I thought it might have been. So, well, welcome tonight.
Judge, I apologize profusely. I'm not supposed to be late for these kinds of things. I'm Joe Benning from Caledonia County.
Nice to meet you.
I'm also an attorney. I've been in practice for 38 years now. I have no idea who's asked you what questions right now, so I'm a little bit reluctant to join into the fray, if you will.
Well, we will move to Senator Nick, who has not taken a turn yet, and maybe you'll catch up, Joe. Thank you. Senator Nick.
I want to say that I really appreciate that you're so well prepared for hearings, and I know that must be taking a lot of time. So, but you do it, and people appreciate it, as was noted in the record here. One of the things I wanted to ask about was the issue of, there was a criticism of you allowing a child to speak in court and taking into consideration their opinions. And I have to admit, some years ago, I remember a judge coming down from the bench and sitting in a regular chair and having had it already prepared and had a small chair for a child. And he sat there, right there, on the floor in front of he didn't sit on the floor, but, right in front of the bench, and spoke to a child there and asked them questions. So I was kind of surprised when someone said that it was not appropriate for the judge to ask a child questions in a custody case. Now, is there some difference between, when a child is a victim of abuse and when there's a custody case going on? I mean, are there some protocols that you're aware of or that I'm not aware of that might indicate that this isn't the way to go?
So thank you. So it is a good question. I would have loved to have been able to speak and have more information from the person that wrote the comment because it is a helpful question. I think it applies to the domestic docket when a child may be a witness involving a motion to modify parental rights and responsibilities in parent-child contact, or to establish parental rights and responsibilities, or relief from abuse order. That's when child testimony comes into play that I have more say-so over as compared to, for example, a family court case involving the juvenile docket where the attorneys would call the child as a witness. I wouldn't speak to the child. I would just be listening to their testimony if that in fact is the case. But in the domestic docket, there is a rule about whether or not a child should testify, Family Court Rule 7. And there has to be a hearing first. A child has to be appointed a guardian ad litem, an attorney, and then the court has to determine whether or not the child should testify. And there are statutory factors that, first of all, would need to be met by preponderance to determine that the value of the child's testimony outweighs any detrimental impact to the child testifying, and that the evidence could not be determined any other way than through the child. So it's pretty rare that children testify in divorce cases or domestic cases. I was counting, I had 4 in the past 2 years. And one of them was a case that I inherited, meaning it was a case that the child's testimony was already a motion that was granted. So in the 4 cases that I had, they were prepared questions through the attorneys. In other words, we had status conferences about what the direct examination questions would be and the cross-examination questions. So it was a script that the attorneys came up with and agreed to. In other words, I wasn't an advocate to say these are the questions that I want to ask the child. I was the person that did, in fact, though, ask the questions. But I never ask a child, where do you want to live? Because it's not their decision. And I would never want a child to have that type of pressure to think that they were the one to make the decision about whether to live with one parent or one custodian versus the other. So that's a question I never ask. But the questions that are asked of a child are the questions that the attorneys have proposed, that I've determined are relevant to the very narrow issue of why it is that the child needed to testify. And then I ask those questions. I typically do that when I'm not wearing a robe, when the child is in the courtroom with me and the guardian ad litem is present in the courtroom, but all of the other parties are remote where the child can't see them and that they are, so it's just the court officer, the court reporter, myself, the child, and the guardian ad litem. And it is not very long. In other words, if a party is successful with meeting that burden of that a child should testify in a domestic case, it is very narrow of the scope of what the child should be testifying about. So the questions are very brief, and in some of the cases, one child was 17, was much older. In another case, a child was much younger, but there's a due process procedure to get even to that point of whether or not a child should testify. The question about that I thought was interesting about whether or not that I listen to the guardian ad litems or allow the guardian ad litems to comment. Guardian ad litems in these proceedings, what they say isn't considered evidence. So I do always ask the guardian ad litem, first of all, if they agree whether or not the child should testify, because I want to know that. That's very persuasive. In all the cases where I've granted the motion for the child to testify, the guardian ad litem was supportive of the child testifying. And then I always ask the guardian ad litem, what are accommodations that you think would be important for this child to testify to mitigate any of the anxiety or the concern or the anxiousness of testifying? But I am cautious about asking a guardian ad litem other questions because I don't want to find out information that I probably shouldn't know. And sometimes more information is presented. So I am probably a little hesitant, but I do ask the guardian ad litem the questions that why they're appointed under the Rule 7. But I thought it was a helpful question and a comment by one of the attorneys for me to just remember to explain why it is that I'm not asking the guardian ad litem other questions. For example, when you met with the child, what did the child say? Because I don't want to know that. I don't think that's appropriate for the court to know. So it's helped me to explain why I'm asking the guardian ad litem questions and why I may not be asking the questions, because I want the guardian ad litem to know that they play a really important role, mostly because we don't really have guardian ad litems in the domestic docket. They are volunteers. So they are extraordinary volunteers here in Bennington County that are putting their time in these really difficult cases. So I'm always grateful when they come forward, and I want to make sure that they know that they're valued. Because we wouldn't be able to do these important cases without them. So I thought that was a helpful comment to just remind me to explain why I'm asking questions, and equally important, why I might not be asking questions of the guardian ad litem. So, but I hope that explains the process of if it's a criminal case or a juvenile case that the state has brought, I don't talk to the child. I do introduce myself and say I'm Judge McDonald Katie. But I don't otherwise talk to the child because that's the role of the advocate to ask the questions. So,
Well, thank you for that thorough explanation. The only other thought I had was, could you speak to briefly just are the guidelines regarding alimony, adequate? Are you able to just give an opinion on that, or are they helpful to you?
So that is an area of law that I hadn't practiced before becoming a judge. So that was another steep learning curve. One, because it involves math. Two, because it's not an area that I feel comfortable with. So it's hard for me to probably have that bigger picture because I don't think I have the depth of experience yet to really comment on that. What I do is I look at the factors in 7552 in Title 15 about, okay, this is spousal maintenance, how it applies. It is sometimes confusing, and I always go back to, all right, what are my factors to make sure, am I applying and considering all the factors in the statute? The bigger picture of are they effective or they aren't, I'm hoping maybe you get to ask me that in 6 years from now and I'd have a better answer for you. But there's some areas that I just don't have that depth of practice to have a really good answer for you because I feel like I'm new and still applying that without, there have been many cases I've had. One of them I shared with you is a writing example of modification of spousal maintenance. But I think I'm still new to really comment on what works or doesn't work with spousal maintenance. I'm hoping maybe I get to answer that question in 6 years, though.
Thank you.
Thank you.
Thank you, Senator Nick. Senator Benning, would you wish to inquire?
Judge, if you have been asked this question already, please let me know. I'm going to go back and watch your interview from the beginning. And again, I apologize for coming in late.
No.
Thankfully, I know all the judges that are on here who have seen me in court know I'm usually the first one to arrive. And I take great pride in being punctual, so I'm terribly embarrassed right now. I did note in one of the comments, and it is only one, an argument about your ability to schedule temporary hearings in a divorce case. Have you been asked that question already?
I haven't, I don't think directly, but I addressed that in my opening statement, but I'm happy to further elaborate on that because I think it's an important comment. So first of all, I do appreciate the comment because time management and being able to manage the docket is critical for a judge. And it is an art. It is something to learn and keep improving upon, and something that I'm hoping to get better and better each day. I do want to take exception that the comment or the person that talked about the law was incorrect. So in Title 15, Section 594A, it is not to hold a temporary hearing in 10 days. It is to hold a prompt hearing. And then for the decision to be issued in 14 days. That was amended in 2017, where initially it said to have your decision in 10 days. So the standard isn't to hold the hearing in 10 days, but it's a prompt hearing. But nevertheless, that became difficult because in the domestic docket here in Bennington, it really could be done 5 days a week full-time, which we don't have. And we have a juvenile docket that can also be run 5 days a week full-time, which we can't have. So I have two competing dockets that really require full-time that I can only give basically half to each during the week. So that right there is difficult when you have many more cases than the hours in a court hearing to hold. What I did do, and I clearly, looking back, the first year of being on the bench was really almost kind of a listening tour, so to speak. I didn't come in saying, I'm going to do this, this, and this. I really wanted to take the opportunity of doing my work, hearing the cases, applying the law, and observing what worked and what didn't work, and not make any great changes because I was new to the job. And I really wanted to learn from the bar, from them, what worked. At the end of the first year, it was sitting down and talking with the COM to say one area that I thought really needed to change was holding emergency hearings in the domestic docket, because hearings are scheduled out really 2 to 3 months in advance. In other words, right now, I have hearings scheduled in June and July in the juvenile docket. And in the domestic docket, I have hearings scheduled in May already. That's how busy it is. So it's difficult to put in those emergency hearings. So I asked the COM and our regional COM in December, could we create an emergency block in the domestic docket similar to what we have in the juvenile docket? Can we do that? And they said, yes, we can do that, but it's going to take a little bit of time because, again, we calendar out so far in advance. But they made that room in the docket so that once a month on the third Wednesday for an hour, we have a block just for emergency cases. So it tries to get those and capture them in 30 days. Because another issue is notice. We have to provide service to the other party for emergency hearings. The other area that I thought maybe a way that we could try to use time more effectively is self-represented litigants, because we have such a large population in the domestic docket of self-represented litigants. And which actually was probably interesting of why there were limited comments, because so many of the people that appear before me are self-represented litigants that I don't think they get access to the survey. So, and in many cases in self-represented litigant dockets, they sometimes don't come to hearings, and then that's a half an hour block where, you know, it wasn't productive, or they may come to a hearing and not really certain about what is contested or wasn't contested. So what I asked if we can create is a self-represented litigant block so that we're hearing multiple cases in an hour time instead of the traditional one case for 30 minutes. Because if self-represented litigants don't appear for a 30-minute case, if no one comes, it's kind of wasted time. So we just started building that into the calendar again, because the docket clerk, the COM, needed time to build that into our calendar. So we just started that at the end of January. So we have that every Wednesday for an hour, where they're putting in 2 or 3 cases right now, and I'm hoping to get up to 4 in the 1 hour. So it's just a really quick status when we have 2 self-represented litigants to explain, are you still contesting this case or not? Are you intending to hire counsel or not? It's a quick ability to kind of figure out how I should better schedule these cases. And when self-represented litigants don't appear, it doesn't take away from time of a 30-minute block that I've lost. So we just started using that, but I think it's going to be an efficient way to try to build some relief pressure in the domestic docket. So I'm hoping that that gives us an ability to hear those hearings quicker. You know, it is still difficult to manage that. And there's always ways to improve, but I identified that even before I read the survey results at the end of the year. But I was also really cognizant of not putting too many demands on our COM and regional COM, because they are really also doing Amin's work of just, they have tremendous responsibility. We are short staffed here where we were down 2 staff members, and that means that everyone has their work, which was a lot, and other work. So I was cautious about adding to new ideas when we were really struggling with just managing to get through the day. But I try to sit down with them at the end of the year to review just these examples. What works, what doesn't, how can I improve? What are things and comments that I can work on for the following year? So we just started that, and I think so far so good. I think it's worked really well, and I'm hoping that that will kind of catch up and give us an ability to hear those hearings quickly, because it is difficult. And when I look at the calendar to say, okay, what can I take off to put instead? All of the cases have value and are competing. They have equal important interests, meaning the contested temporary case and the juvenile case that needs to be heard timely, or the contested divorce case where the parents have been waiting for a year and want that resolution and have children. There are no easy cases to say, this case can wait. So that's also the challenge of beforehand of saying, okay, let's just take this one off and put this emergency in its place, because everyone is waiting for their time in court, and there's just not enough time to hear all the cases. So it's trying to be creative. So I hope that those are 2 ways that I tried to be creative, and we'll see how that works. But
I appreciate your answer. It sounds like you've taken care of my concern. And yes, I do understand the delicious irony of the person asking you about time management is the one who showed up a half an hour late to your meeting here tonight. Thanks.
thank you.
Thank you, Senator Benning. So Judge McDonald, Katie, I don't really have any questions. They're all asked by the time the chair gets to inquire. So I do have some comments though. And, you know, having spent 35 years in courtrooms in the Northeast Kingdom, I would have to say that what you do as a new judge, or what you are doing as a new judge, to help you to determine how a person got into your courtroom, what the circumstances are surrounding that, and how you may be able to proceed in a way that would benefit all parties. So make no mistake, that is, in my opinion, what you should be doing. It really benefits the community and the litigants that appear before you, and the defendants that appear before you. It benefits them a great deal for you to have that understanding, because then you are more prepared to make a very difficult decision at some time, in some cases, and proceed with some caution, but with respect to all the parties. And we are seeing that in the responses that we received, the written responses. At the same time, I don't want to harp on this, but you know, you're not the first one who's been accused of being a social worker judge in the time that I've been on these committees. So what you have told us that you realize is that to expedite your docket and to try and keep things running on time is something that you understand, and that it is sometimes a difficult line to walk between getting to know the information that you should have to make these difficult decisions and to move your docket along at a speed that is expected of you by both the court and the attorneys and litigants that appear before you. So, those are my comments. Yeah, I think I'll leave it at that. I appreciate your understanding for all the comments that were made, and that as a new judge, we can hope that you will take these to heart, and we know apparently that you will take these to heart
Yes.
and just become a better judge.
Thank you.
Let's see. We have the only individual that has requested to testify coming at 6:30. Is that correct, Peggy?
Yes, I told her it starts at 6:30.
Okay, so it gives us about a half hour. Is there anything else from anyone on the committee who would like to add to this at this point?
Yeah.
Yes, Senator Cormack.
I had prefaced my remarks by pointing out that all the negative comments were outliers. And I just want to again re-emphasize that. If we didn't talk about the negative comments, we wouldn't have had that much to talk about. So that's what we focused on. But I just wanted to wrap up this by acknowledging how overwhelmingly positive your comments were. That the folks who work with you seem to think you're doing a good job.
Thanks, Senator McCormick. So it does give us a half hour downtime here. I'm not sure. I guess we just